The Arizona Statute of Frauds, found in ARS paragraph 44-101, is one of the most important legal doctrines in real estate law. It was created to prevent fraud and misunderstandings by requiring that certain types of contracts, including those involving real property, be in writing and signed to be enforceable. In real estate, the statute ensures that every significant agreement, such as the sale of land, long-term leases, or brokerage employment contracts, is clear, verifiable, and legally binding. Its primary purpose is to protect both the public and real estate professionals by providing tangible proof of the parties' intentions and the agreed terms. At its core, the Statute of Frauds establishes that oral agreements related to real property are not enforceable unless they are properly documented in writing. For a real estate contract to satisfy this law, it must include several critical elements: the identification of the parties involved, a clear description of the property, the consideration or purchase price, and the signatures of the parties being charged. Without these components, no party can compel performance under the law. For example, if a seller verbally agrees to sell a parcel of land but refuses to sign a purchase agreement, the buyer cannot legally enforce the sale. Written contracts are not just a legal formality. They are the foundation of trust and accountability in real estate transactions. In the context of real estate purchase contracts, the Statute of Frauds is particularly significant. Under ARS paragraph 44-101, all agreements for the sale of real property must be in writing and signed by the party against whom enforcement is sought. The written document must clearly outline the property, the parties, and the price. Arizona courts, including in Best v. Edwards, 1991, have upheld that even multiple documents, such as signed letters or emails, may collectively satisfy the statute if they clearly indicate an agreement. Electronic signatures are also valid under the Arizona Electronic Transactions Act, ARS, paragraph 44-7001 E-SEQ, allowing licensees and clients to execute legally binding contracts through digital platforms such as DocuSign. Although the Statute of Frauds requires most real estate agreements to be written, Arizona law recognizes a few exceptions where oral agreements may still be enforceable. These include partial performance, promissory estoppel, and admission in court. Under the doctrine of partial performance, if one party takes significant action that clearly demonstrates the existence of an agreement, such as taking possession of the property, paying part of the price, or making improvements, a court may enforce the oral agreement to prevent injustice. Promissory estoppel applies when one party makes a clear promise that the other reasonably relies upon, and failing to enforce it would cause significant harm. For example, if a seller verbally promises to sell a home and the buyer spends money on inspections and moving costs based on that promise, a court may recognize the agreement. Finally, if the defendant admits in court that an agreement existed, that admission removes the need for written proof. Additionally, short-term leases, 1 year or less, are exempt from the statute and may be enforceable even if made orally. Perhaps one of the most practical applications of the Statute of Frauds in real estate is its requirement for written employment agreements between licensees and clients. According to ARS, paragraph 44-101, any agreement authorizing a broker or agent to sell, purchase, or lease property on behalf of another for compensation must be in writing and signed by the client. This rule ensures clarity regarding representation, compensation, and the scope of authority. Without a written agreement, a broker cannot lawfully claim or collect a commission. This principle was upheld in Butterfield v. McKenzie, 1966, where the court ruled that an agent cannot recover a commission without a valid, signed listing agreement. The same requirement applies to buyer-broker and property management agreements under ARS, paragraph 32-2151-02, which mandates that all employment agreements contain a definite expiration date and a clear description of the services to be performed. The Statute of Frauds is reinforced by Commissioner's Rule R428-1101A, which requires licensees to exercise reasonable care and skill in representing clients. Ensuring that all agreements are properly documented is part of this professional duty. Brokers are also required under ARS, paragraph 32-2151.01, to maintain all written contracts and agreements for at least 5 years to ensure compliance and to provide evidence in case of a dispute. In summary, the Arizona Statute of Frauds is the backbone of legal enforceability in real estate transactions. It ensures that important agreements are written, signed, and preserved, reducing the risk of fraud and misunderstanding. It protects consumers by requiring transparency and safeguards brokers' rights to compensation through written employment agreements. The few exceptions to the statute exist to prevent unjust outcomes, but they are narrowly applied. Ultimately, for Arizona licensees, adherence to the Statute of Frauds is not only a legal obligation, it is a cornerstone of ethical and professional real estate practice. Key points to remember for testing ARS. Paragraph 44-101 establishes the Statute of Frauds, requiring certain contracts, especially those involving real property, to be in writing and signed to be enforceable. Real estate purchase contracts must include identification of the parties, property description, price, and signatures under ARS. Paragraph 44-101. Exceptions to the statute include partial performance, promissory estoppel, and admission in court, as well as leases of 1 year or less. Employment agreements between brokers and clients, such as listing agreements and buyer-broker contracts, must be written and signed under ARS, paragraph 44-101, and ARS, paragraph 32-2151.2. Brokers cannot claim commissions without a written agreement, as established in Butterfield v. McKenzie, 1966. Electronic signatures are valid under the Arizona Electronic Transactions Act, ARS, paragraph 44-7001 SEQ. Maintaining written records for at least 5 years is required under ARS, paragraph 32-151.01. Study tip: when preparing for your test, focus on identifying which real estate agreements must be in writing, understanding the exceptions that allow enforcement of oral agreements, and recalling the specific statutes, especially ARS, paragraph 44-101. Remember that the Statute of Frauds protects both consumers and licensees by ensuring every contract is legally enforceable, professional, and transparent.